Question from the Modern Divorce Support Group, and yes, we are trying out a longer blonde today. My son was not put on the birth certificate when he was born. The hospital wouldn't let us because we were not married. He was born in 2007 and we split up in 2010. For the first 6 years, we co-parented great until 2016 when my ex met his now wife and everything went to hell. He suddenly wanted our kids to come live with him. He wanted to change their school. He flat out told me that she worked from home so she could watch our boys during the day. And he thought this would be better for the boys than them being with me. We've been in and out of court ever since. He punched my oldest in the face, giving him a black eye when he was 10. He sat in front of my house for days when our youngest was sick with COVID and didn't go for the weekend visitation, which prompted a restraining order. It's been chaotic. He got a declaration of parentage in 2016 when we first went to court. But suddenly, our youngest is now 16 and a half, and he wants me to get a form that notarizes saying that he is the father and his name needs to be put on the birth certificate. I may be overly suspicious after years of lying and mind games, but I can't wrap my head around why this is suddenly so important and dire when in a year and a half he will be 18. Our original order's from California, but we all moved to Arizona after a long court fight about us moving. He still has every other weekend and almost all the summer. I have sole custody and legal decision making for educational and medical, and I have several questions. How do I transfer the case to Arizona? And since he already has a declaration of parentage signed by a judge, why is this necessary? He's threatening court action if I don't sign and get it notarized. Hello, my name is Billy Tarasio. This question is from the Modern Divorce Support Group. There's lots and lots and lots of comments, but let's start with the first question. How do I get the case transferred to Arizona? This happens a lot. So when nobody lives in the state of the original jurisdiction, that original state loses jurisdiction over the case. So I'm assuming dad lives here in Arizona as well because he has every other weekend, but it's possible he's still in California. So I'm going to go through both scenarios. Either way, you need to get a certified copy of the former orders and register them here in Arizona. Then the next time anyone needs to file something, you file it in Arizona and you argue that under the UCC JEA, Arizona is the state that now has jurisdiction. That is plain and simple if dad lives here. Even if dad doesn't live here, you then need to argue that this is a more convenient and appropriate form given the fact that you've lived here for so long and all the evidence and all the witnesses are here. That's how you do part one. Part two, can he take you to court if you don't sign a document and get it notarized stating that he can be added to your son's birth certificate? If there is a court order that directs you to add him to the birth certificate, then yes, you could be held in contempt. If there's not that very direct order telling you that you need to add your son to the birth certificate, then you can't be held in contempt. But if you do end up in court about this, the judge is probably going to tell you to go ahead and sign the document and get dad added to the birth certificate. I don't see a lot. I know you're suspicious of dad, but I don't see a lot of ways that this could kind of come back to bite you. I don't see any downsides to you to signing the form. I hope that helps.